petition in the matter of S3D Interactive Inc. Oovee Ltd.
My lord, my lady, I appear for the respondent in this appeal and applicant in these applications. Mr. Slade appears for the appellant and the respondent to these applications.
Yes.
First, can I thank the court for hearing these applications urgently? Second, the parties jointly request that this hearing is in private and therefore that it's not streamed. And the reason is because it relates to a confidential arbitration conducted under LCIA rules.
Yes.
Now, the court, as my lord, my lady will know, the court may order that an arbitration claim can be heard either in public or private. And pursuant to Rule 62.10(2), the default position, given that this is not a hearing relating to either Section 45 or 69 application, is that the arbitration claims are heard in private.
Yes, but you still have to justify it.
Yes. The hearing before the judge was held in private. The judgment, the subject of this appeal, was anonymised before being published. And so the consequence is that if this hearing is held in public, then that is likely to negate the efforts thus far to keep the subject matter of this case confidential. And my lord, my lady will be aware that one of the issues on the appeal relates to the confidentiality. Well, in fact, the only issue on the appeal relates to the confidentiality of the arbitration generally. And so for those reasons, we say this.
Well, the issue is that a whole load of material has been put in the public domain already.
Well, that is an allegation, my lord.
Well, the allegation is that you did it.
Yes.
Is it disputed that material has been disclosed?
Yes, my lord. Without going into too much detail on the appeal, there are certain acts of providing materials that are alleged and admitted. It is denied that the result of those acts is that the materials or the information contained in those materials have been made public generally.
But it has been released too. I mean, the confidentiality has been lost.
My lady, we say no.
Well, even though it's been delivered to third parties.
Well, whether it's a third party, a genuine third party or not, is an issue in the arbitration. So we say that the provision of materials to that party, to use a neutral term, did not destroy the confidentiality of the arbitration. Well, it wasn't a breach of the rule, the LCIA rule, number one. And secondly, even if it was, it didn't destroy the confidentiality of the arbitration more generally. Because there is then the issue as to what was made public by that party, by communications with journalists. But the potential consequence of having this hearing and indeed the appeal, the substantive appeal, in public would be that, to put it beyond all doubt, that the dispute in the arbitration and certain elements of the arbitration would be in public. And in my submission, efforts should be made to prevent that happening, when, as I say, it is an issue whether the arbitration generally has been made public.
What about all these other proceedings that are going on, apparently? That must reveal quite a lot to anybody who's interested that there is a dispute between these parties.
It certainly reveals some things. It reveals, and this again is straying into submissions that may be made in the substantive appeal, but it certainly, and indeed in the arbitration itself, when it comes to that, it's certainly the case on our side that the fact of the arbitration is public, and that the overall claim in the arbitration is public as well, independently of any of the acts that are alleged
So that's why there's nothing wrong with listing this matter by reference to the parties' names.
No, that was a mistake, my lady.
No, it wasn't.
Well,
I mean, if
No, it wasn't. It wasn't a mistake. There was no application for anonymity, and there has to be. This court sits in public and operates in public unless an application is made to the contrary. It was not a mistake.
my lord, my lady, I misspoke. It was a mistake to, on the party's side, to allow that to happen. So that was an oversight.
Forgive me, just moving away from the detail of the substance of the arbitration.
Yes.
As I understand your submission, the fact of the arbitration between these two parties is in public. So to list...
Well, I need to be careful, my lady, because that's certainly my case.
Right.
In the arbitration and on the appeal. It may not be the appellant's case.
Right.
So I need to be careful.
I see.
In agreeing with that.
Right. Anything further
No,
on this?
No, my lord, my lady. Grateful.
Mr. Slade, your position?
My lord, Mr. Akins asked me before we started what my position was. I said to him that I was prepared for the application he's just made to the court to be made on a joint basis. But in answer to your respective questions, the position is that it is an admitted fact that Pinsent Mason's solicitors for the applicant disclosed to press consultants retained by them on their client's behalf every single statement of case in the arbitration.
Where is that admission? It's an admitted fact. Is that? Do we have that in our?
I
don't worry. It is
right.
Right.
In correspondence. Right. That event happened, and it is also an admitted fact that two very lengthy, detailed press articles appeared as a result of those press consultants' activities. One journalist was briefed by officers of the applicant directly in the presence, I believe, of the press consultants, and that has been put in evidence. What else happened, we don't yet know. There's been no order, either in the arbitration or any other set of proceedings, or disclosure to us what has happened. I've told the court what I'm aware of. And on that basis, it's certainly true that a large measure of the confidentiality surrounding the arbitration has been lost. And that, of course, founded the step which my client took.
Yes, that's the
issue.
Yes. No, we understand that, but we're at the moment just interested in the fact of what is acknowledged to have happened. Yes, all right, thank you. Is there any dispute about that fact that Mr. Slade just told us about?
The provision of arbitration documents to the public relations firm? No, that's not in dispute. I do take issue with what is said with respect to communications with journalists.
But it's not in dispute that press articles have appeared?
Yes, the dispute is over whether they disclose any confidential information about the arbitration. Because, as my lord has already mentioned, there are a number of disputes between these parties. Only the arbitration is private. The other disputes are public. So our case is certainly that the press articles do not disclose any confidential information about the arbitration.
Wouldn't it be possible to have this, on these two applications, be possible to conduct the hearing without referring to, even on your case, what you say is confidential information?
It may be.
And we should strive. There may be a principal position to take overall, but is there a more nuanced situation, which is simply that we watch what we say?
Yes, I mean, I have in mind particularly that there is a complaint in the allegation of breach of the arbitration agreement that a specific piece of confidential information was made public, which is the subject of the Section 42 application which is now subject to appeal.
But we probably don't need to go into that for the purpose of these applications about lifting the stay and security for costs, do we?
It is certainly not in my notes, put it that way. So with everybody being careful, and yes, then
Yes.
perhaps we can see how we go.
Right. We'll rise for a moment.
Court's rise.
We have before us two applications by the respondent to the appeal. The first is an application to lift a stay of the order made by Mr. Justice Butcher, which requires the appellant to provide security in a large sum by the 28th of November 2022, and which has attached to it a penal notice. The stay was imposed by Lady Justice Carr, without a hearing, but with liberty to the respondent to apply. The second is an application for security for costs of the appeal. Until this morning, no application had been made for these applications or the appeal to be conducted in private, or for the names of the parties to be anonymised. Accordingly, the applications were listed for hearing in public under the names of the parties. This morning, an application was made informally by Oovee, the respondent to the appeal, and the applicant in the present applications for anonymisation and for this hearing to be heard in private. That application has now been repeated orally at the commencement of the hearing by Mr. Akins, counsel for the applicant, the respondent to the appeal. It has been presented as a joint request by the parties that we should sit in private. The ground for that application is that the proceedings concern a confidential arbitration. I would refuse that application. As I explained in CDE and NOP 2021 EWCA Civil 1908, a case in which the court did sit in private, the provisions of CPR 39.2 do not apply to the hearing of an arbitration claim, which includes any application to the court under the Arbitration Act 1996, see CPR 62.10. Nevertheless, the provision in CPR 62.10(3) for arbitration claims, with some exceptions, to be heard in private, is only a starting point. See Department of Economics, Policy and Development of the City of Moscow and Bankers Trust Company, 2004, EWCA Civil 314, 2005, Queen's Bench 207, and Manchester City Football Club and Football Association Premier League Limited, 2021, EWCA Civil 1110. It remains necessary to have well in mind all the reasons why it is of fundamental importance for court proceedings to be conducted in public, so that there is proper public scrutiny and accountability, and to balance this against the significance evidence of arbitral confidentiality in any particular case. In the present case, I have no doubt that these applications should be heard in public. First, whatever the position in the commercial court, these proceedings are taking place in the Court of Appeal. In granting permission to appeal, the judge must have taken the view not only that the appeal had a real prospect of success, but that the appeal raised a point of some general interest under Section 42 of the Arbitration Act 1996. He was right, in my view, to take that view. Accordingly, the balance between the imperative of open justice and the confidentiality of arbitration proceedings may fall to be struck differently in this court from the way in which it is struck in the commercial court. Second, I am not persuaded that hearing these applications in public will disclose any information which is genuinely confidential. Indeed, we note that it is a foundation of the appellant S3D's case that Oovee has already put into the public domain, wrongfully as the appellant says, all of the statements of case in the arbitration, as well as the request for arbitration and S3D's response. Oovee contends that S3D did this by providing these materials to public relations consultants and journalists, but S3D was thereby in repudiatory breach of its obligation under the LCIA rules to maintain the confidentiality of the arbitration, and that it has accepted that repudiatory conduct as terminating the arbitration agreement and bringing the arbitration to an end. Whether these contentions are well-founded has yet to be determined. As I understand it, Oovee accepts that these materials were disclosed to press consultants by its solicitors, and that press articles have appeared which at least say something about the arbitration. In these circumstances, there is at least a real possibility that any confidentiality which the arbitration may have had has already been seriously compromised. Third, the arbitration is not the only proceeding where the parties are in dispute. According to Oovee's own evidence, S3D has launched no less than 13 sets of proceedings against it in the United Kingdom and the United States. As at June 2022, there had been apparently 13 public proceedings between these parties, including various UK IPO, US PTO, and EU IPO trademark oppositions, and court proceedings in New Jersey, Washington, and the United Kingdom. Accordingly, there is already substantial publicly available material regarding the parties' dispute, irrespective of S3D's allegations as to repudiation of the arbitration agreement. Fourth, the order which Oovee sought and obtained from the judge under Section 42 contains a penal notice, so that if the appeal fails or if the stay is lifted as a result of the present application, S3D and its directors will, at least potentially, be subject to the sanction of contempt of court in the event of non-compliance. That is itself a reason why these proceedings should be heard in public. People should not be at risk of contempt as a result of proceedings heard in private or anonymously, save perhaps in exceptional circumstances not present here. Accordingly, these applications will be heard in public, and the names of the parties will not be anonymised. However, the parties should not refer to anything which is or may be genuinely confidential about the arbitration proceedings, unless it is necessary to do so. In that event, the matter should be raised with the court before whatever it is mentioned. For the avoidance of doubt, this ruling does not purport to bind the Constitution hearing the substantive appeal, but if any application is made that the substantive appeal should be heard in private, a copy of this ruling should be provided. Right, we'll now continue with the applications.
Thank you, my lord. My lord, my lady, can I just check that you have the following materials: skeleton arguments from both sides.
Yes, thank you.
A core bundle prepared by the appellant should have been received in PDF.
Is that the same as the original PTA bundle, or is that something different?
There wasn't there wouldn't have been a PTA bundle,
Oh, wasn't
because
there?
that was,
Oh no, of course there wasn't.
permission was granted by the
Permission was
judge.
granted.
Yes. So but it has, it'll have the appellant's notice as the first
Yes.
document.
Yes, well, I've got that, has my lady.
Yes, I've got it.
Good.
Yeah, it's right.
An application bundle prepared by the respondent, which has the evidence for these applications.
Yes,
And,
I've got that. I think we both got it electronically.
and an authorities bundle, which you'd have electronically as well.
Yes, thank you very much.
So, my lord, my lady, I would start with the set-aside application, if that's convenient.
Yes, certainly.
And that's my skeleton, paragraphs 7 to 20. And I've set out the applicable principles in paragraphs 8 to 11, with a particular reference to Matani and Sippy. I don't detect that there's anything between the two sides on those principles.
No, I didn't detect anything either.
The general starting point is neither the commencement of an appeal nor grant of permission to appeal affects the enforceability of a judgment below. A stay is the exception rather than the rule.
Yes.
A party seeking a stay must put forward solid grounds. These solid grounds are normally some form of irremediable harm if no stay is granted. And then if solid grounds are put forward, then the court must consider all the circumstances and the risks of injustice to one or both parties if it grants or refuses the stay. And one of the factors to consider is whether, if a stay is refused, there is a risk that the appeal is stifled. But there is no suggestion that that would be a consequence of refusing a stay in this case, so that is not a factor for the court to take into account. So,
Yes.
first, are there any solid grounds for seeking a stay, or indeed maintaining a stay in this case? The appellant's reason for seeking a stay is that if a stay is not granted, S3D, its directors and officers, will be exposed to penal consequences and potential sanctions for non-compliance with the order for security, in circumstances where there is a real prospect that they should not have been exposed to such consequences in the first place. So let me take my lord, my lady, to the order itself, which is at page 32 of the core bundle, PDF page 32 of the core bundle. If my lord has, or my lady has a hard copy, unfortunately the page numbers don't match up, so it's page 30 of the hard copy.
Yep. Actually,
So
my bundle doesn't have pagination at all. It must be an earlier version. But anyway, I've got the order. So
Right, thank you. So you see the penal notice on
Yes.
page 1 of the order, and then the paragraphs sought to be stayed are paragraphs 2 and 3. And given my lord's caution earlier, I won't read it out.
Yes.
Now, there are 3 points in my submission to note about the specific circumstances of this case. First, as far as the penal consequences are concerned, the court will appreciate that that was the whole point of making the application and granting the order in the first place, that the order for the provision of security had a penal notice attached to it. This hearing is now the 5th time that a tribunal has looked at the issue of security of the award, and it was necessary for the judge below to grant the order with a penal notice because the appellant have not complied with the security orders of the arbitrator.
But that is the order that is under appeal.
Yes. Second, the arbitrator rejected the appellant's argument that it was unable to provide the security on 2 separate occasions. And the judge below rightly did not revisit that aspect of the arbitrator's decisions. And
What
that-
happens if we lift the stay and the order is not complied with, and you seek to commit somebody to prison for contempt, to which the response is, we couldn't comply, we didn't have the money.
Well, that will be a factor in addressing that contempt application.
And that would be that would be something that you would need then to prove, is it? That they could have complied?
Well, I would say that the burden is really on the other side, but that would certainly be...
Well, the burden would be on you to prove to the criminal standard that somebody's in contempt. Is it an element of that they could have complied with the order that you would need to prove, or is it a factor only going to mitigation of sentence if they can say we couldn't comply? How does this work?
Well, my lord, as I say, that would be a question for the contempt proceedings, and it would remain to be seen what the parties, and in particular the respondents' case was in those contempts.
All right. Anyway, your position is that if the stay is lifted and they don't comply, then they'll be in contempt.
Yes. And it is not, given what the arbitrator has found, and given the judge's rightful rejection of that point below, and the third point on the specific circumstances of this case is that permission to appeal was not granted in relation to that point, the unable to pay point. It's a very narrow point of principle that the judge saw.
Well, I know, but on the whole, we don't send people to prison because of something that an arbitrator has determined.
Well, that may be, but these were all arguments that were raised before the judge below.
But the contempt hearing will judge whether, as at the 28th of November, there was a deliberate breach or not.
Yes, that's right. Exactly. That is all a matter for the contempt.
But therefore, past findings as to what the position was in, I don't know, July or April of this year may be nothing to the point.
They may be nothing to the point, but we have no visibility on anything.
But just to go back, because it's obviously very important for the purpose of the balancing exercise, your position is very simple, that if there is no compliance by 4 o'clock on Monday, then there is contempt on the part of S3D and its directors and officers.
They will be in breach of the order, which has been marked with a penal notice. Yes, that's the entire point of granting the order.
So yes, thank you.
No, that's clear.
But I go back to the point that is not, the unable to pay point is not something that it is legitimate for the court to take into account when considering whether to grant a stay in this case, because of the judge's decision below and the fact that it is not subject to permission to appeal.
Yeah.
And so we say the consequence of those 3 points that I've just mentioned is that the court must proceed on the basis that the appellant is able to provide the security and thereby avoid the penal consequences and potential sanctions. That must be the right basis on which to proceed, given the history of these proceedings and where we are on this appeal. If, notwithstanding its ability to provide the security, it chooses not to provide it, then that is hardly the court's or the respondent's concern.
Could you just remind me where in the judgment below Mr. Justice Butcher found the ability to pay?
59 to 60.
Thank you.
So PDF page 53, so it'll be
Yes,
page
no, I have it.
55.
Thank you.
So that is why, that is the core reason why we say they are not solid grounds for granting the stay in the first place. The appellant also says if a stay is not granted, the respondent may seek to argue that the appeal should not be heard if the appellant is in contempt of court.
Sorry, can you just remind me what's the date of procedural order number 13?
Procedural order 13. So it will be in the chronology
Yes, it's in the.
of my skills.
So number 8 is 25th of August 2021. That's the date of number 8.
Yes.
And number 13.
It's the 16th of June 2022.
Right, thank you very much.
So yes, I was just addressing the appellant's point, said that if a stay is not granted, the respondent may seek to argue that the appeal should not be heard if the appellant is in contempt of court. To which I respond as follows. First, we're not there yet. And secondly, this assumes that they will not comply when the argument that they are unable to comply has been rejected. And Miley, just to go back to the point about whether things might have changed, that may be something that the appellant seeks to run at an appropriate stage. But one needs to appreciate the history of these proceedings and the recalcitrance of the appellant in this case, and its failure to bring to explain these matters. There's no evidence before the learned judge, before the court on this appeal, as to its inability to pay, even if that was open for the court to consider, or as to any change in circumstances at all. Its position throughout has simply been, I'm not going to pay, I'm unable to pay. And that's it. This is not a party who has brought evidence to the arbitrator or the court, which goes into some detail as to the asset position and seeks to make a detailed and forensic case as to why it's unable to make these payments. It's been found to have dissipated assets, and then it simply stood up and said, I can't pay these sums, except when it's in its interest, of course, when it has to pay security in order to pursue a claim or an appeal. It's very important that the court has that in mind.
Yep.
So, on the assumption that it is able to pay, there can be no irremediable prejudice to the appellant in lifting the stay. The security will be provided as ordered. If the appeal is successful, it will be returned. The security is not going to the respondent, so there is no risk that the respondent will spend it or put it out of reach while the appeal is pending. So the simple fact that the appellant will be forced to comply with an order, which might subsequently be set aside, is not, in my respectful submission, a solid reason to grant a stay. That would apply to all orders under appeal, so would be inconsistent with the guidance in the authorities and the CPR that no stay is the default.
Right.
So we say there are no solid reasons for maintaining the stay. By contrast, there is a serious risk of injustice to the respondent if the stay is maintained. The appellant was ordered to provide security for the award in September last year because it had been dissipating assets. That was the reason. The respondent was forced to seek a Section 42 order from the court in order to enforce that order in the face of the appellant's recalcitrance. The trial of the arbitration is due to start on 12th of December.
How long is it expected to last?
5 days, so 12th till the 16th.
Thank you.
So we've been without the security that's been ordered for 14 months. Now, the appellant says that no injustice would be caused because Oovee has never had the security for the award. In my submission, that's completely the wrong way around. The respondent can hardly rely on its own recalcitrance. The fact that the respondent has never had for security is precisely the reason why the stay should be lifted as we submit. The respondent should have had that security and should have its security for the last part of the preparation for the trial of the arbitration, the most intensive part, of course, and for the start of the trial of the arbitration itself. If the court allows the appeal before the trial starts, then, as I have said, the security can be returned and there's no prejudice to either side. But in the meantime, given the respondent was successful before the judge, the security should be provided. So for all those reasons, there are no solid reasons for maintaining a stay when one truly understands the background to the case and the scope of the appeal. And even if there were, the risk of the injustice to the respondent, if the stay remains, far outweighs the risk of injustice to the appellant if the stay is lifted. So for those reasons, the order should be set aside.
Yes. Yes. All right. Well,
those are my submissions on the set-aside application. I can continue on security if you wish.
Well, at the moment, we are minded to be with you on security for costs in principle. Perhaps you could tell us precisely what order you're asking us to make in terms of the mechanics.
Right. So the order that we sought, which was back in, well, we first requested £20,000
yes,
by way of security on the 16th of November, and that's what we've sought in the order, the draft order
yes,
of the application on the 17th. And
yes,
we've sought that by 4 p.m. on Monday.
And you want an unless order?
Yes, my lady.
yes. All right.
Does that answer my lord's question? Are there any other details that?
Yes, no, I think that's what I wanted to find out from you. Yes, all right. Thank you very much.
Thank you,
Mr. Slade.
Lord, would you be happy if I just start with security costs?
Yes, by all means.
It's accepted on this side that the company is a foreign company and that there is reason to believe that it would not be able to pay Oovee's costs of the appeal were it to be able to do so. So we can put that to one side, that's all common ground.
Yes.
It turns on discretion. And I believe it's a point which is well established, where a party has already sunk quite a lot of money in proceedings in which security is later sought, it is normally inappropriate for the court to impose an order for security at that stage on the basis really of procedural affairs. It's a bit like changing the rules after the match has started. That's the way it's sometimes put. I say that for what it's worth. The court will have its own view of what is going on in this case. Can I, however, just make a couple of totally practical points that perhaps come better from a solicitor than from counsel on this occasion? I don't know whether anybody realises this, but the Court Funds Office is in Sunderland. It used to be in Glasgow, which I pointed out once was actually outside the jurisdiction of this court. But it's in Sunderland. It only takes payments by cheque, even in this day and age.
But it seems to me that if, in principle, security for costs is going to be ordered in what is, by the standards of commercial litigation, a relatively modest amount, then it would be very straightforward for the money to be transferred to your firm's account and for you to give an undertaking to hold that to the order of the court.
Yes, well, that would be a simple reason. There are 6 days between now and the start of the
Yes.
now and the hearing of the appeal. The money would have to be wired from America. I say that for what it's worth. The simple point is that this is an unusual application in that I don't criticise at all the timing. Simply that the timing for all of us is so compressed by the circumstances that there are practical difficulties. And I'd rather take the view in this case, and I replied to Vincent Mason's refusing to provide security, that it was just rather impractical to raise that over a small sum of money at this stage in things generally. If the court feels that security should be provided, I dare say security can be provided. We will deal with it. Coming on to the question of the stay, Mr. Aikins urged upon the court the proposition that, first of all, the judge had found that the company was able to pay, and that even if he hadn't, the arbitrator had, and that this court was bound by one or other of those findings. Well, first of all, the judge did not find that the company was able to pay. He considered the arbitrator's decision, and he decided that he could not or would not interfere with it. That's not quite the same thing.
Yes.
Secondly, when the arbitrator made that decision, he was exercising, in effect, a case management power. We called that, I think, in the context of court proceedings. He based his decision on whatever factual findings he made. But all of that was done, obviously, on the balance of evidence. He was not exercising anything like contempt jurisdiction. And for that reason, I take issue with the proposition that we should consider ourselves bound by any of these findings in this court today. We're considering here possible penal sanctions, and the court dealing with any breach in the future and any application for committal for contempt would have to deal with the matter afresh, obviously. I say that simply because the order made by the judge is an order for the payment of money in a substantial sum, and it is not usual to back up such orders with penal notices. I think the only reason it got through, if I can put it in that way, is that it was regarded as a case management decision and the payment of security. But if we turn to penal sanctions for non-compliance, it doesn't really make any difference whether it's for security or not. The money still has to be paid. And we're talking about, therefore, potential sentences of imprisonment for the non-payment of money. And that's a very uncomfortable subject indeed, and one I would submit the court should, as it has done to date, treat with great caution. The court was obviously concerned, the court in the person of Lady Justice Carr was obviously concerned when imposing the stay on the papers, that we had a situation where potential non-compliance and therefore penal sanctions could become relevant as soon as 4 o'clock on Monday. And going back to the practical point that I made, the benefit of this stay lasts for a further 6 working days only. Oovee complains that it will be deprived of the benefit to it of the provision of security if the stay is not lifted. The reality is that the position will become clear on the determination of the appeal on the 6th of December.
Well, I must say you can't necessarily assume that the Court of Appeal will be in a position to tell you its decision on the 6th of December. It may be and it may not be, and obviously we can't commit whoever is on the Constitution, which is the appeal. But I'm sure they will appreciate the need to give you a decision as soon as they can.
Yes, my lord. But of course, the hearing of the arbitration, the dispositive hearing in the arbitration starts on the 12th, and I had it in mind that perhaps it would be one of those cases where a written judgment followed.
Well, all possibilities are open.
Yes. Going to the nub of this, the question for the court on this application is the old one of doing the least harm in the circumstances, balancing the position between the parties, and trying to decide which injustice would be worse. The potential injustice to S3D is that it and its officers will be put in jeopardy of penal sanctions on the back of an order which, if S3D wins the appeal, will be an order that was wrongly made.
Yes?
We say in the appeal that the judge ought not to have made that order because at that stage, the question of the arbitrator's jurisdiction had not been determined. Now that's not a criticism judge, and it's not a criticism of the arbitrator. It's simply a statement of fact. The arbitrator had, as he was entitled to do, reserved the question of his jurisdiction to the end of the proceeding before him. But the consequence of that was that the judge could not know when he made his order whether the arbitrator had jurisdiction or not, according to his own determination of that question. And we say, in those circumstances, the court should not proceed to make an order on a peremptory order with penal sanctions. Now, the stay holds the ring until the appeal. I come back slightly to a point I made just now. The potential injustice to Oovee, which the court has to take into account on the other side of the balance, is that it's unable to enforce its entitlement to security prior to the commencement of the arbitration. But that injustice will last simply for a matter of 6 days. That is, of course, if Oovee were to win the appeal. In that case, the stay would fall whenever the decision of the Court of Appeal was announced, and it would have its enforceable order, presumably prior to or close to prior to the commencement of the arbitration, which is what it says is important to it. The stay only postpones that state of affairs, assuming in Oovee's favour that it wins the appeal by 6 days. But on the other side, the authorities speak of irremediable harm. My submission to the court is that putting people at risk of penal sanctions is irremediable. The sanctions may not be carried out. The sanctions may never come into consideration at all because the company complies. But to put somebody at risk of penal sanctions, the non-payment of money, is a very serious thing indeed. And that, I would submit, is something that cannot be. Even if the sanctions are subsequently lifted, there will have been a period of time during which those sanctions would have been operative on the minds of those to whom they are directed. And that, in my submission, is something which the court should not countenance in circumstances where the appeal will determine whether the order to which the penal notice is attached is an order which should have been made or should not have been made. And if it should not, it would be very regrettable indeed if the individuals in question should have spent a period of time in fear of penal sanctions.
Yes, all right. Well, that's really your point, isn't it?
That's my point.
Yes. All right. Well, thank you very much. Anything in response on that?
Yes, very briefly. Just on the security, the costs, my lord raised the practical possibility of a different form of order, and that being the money being held on account in the solicitor's account, and we'd have no objection to that on this side. Then, in terms of the stay and lifting the stay, my submission that this court is not exercising a contempt jurisdiction on this application, and it is not looking at whether on the criminal standard there will be a breach of the order if the security is not provided. That's the first point. So that is not the right prism, in my submission, to look at this application through. The second point is that the point of the penal notice is to make sure that the appellant does what they've been ordered to do in circumstances where they won't do it absent that. That is the whole purpose of the penal notice, and that's why it's necessary. And so that is the right way to see the penal notice. In this case, it's a measure to force them to do what has been found they can do. And on that last point, the fact is that it can pay. We have no visibility of the actual asset position of the appellant. We do know, and this is not controversial, that its litigation is funded by a multi-million-dollar company. That's not controversial. That multi-million-dollar company is a subsidiary of a multi-billion-dollar company. Again, that is not controversial. Those are the facts that we do know in this case, and that is why the arbitrator came to the decision it has, and that is why this application cannot proceed where there is a dispute as to whether the appellant can pay or not. Those are my submissions.
All right. Well, thank you both very much. We'll rise for a short while.
Whatever they decide, will you let us know about? I'm sure that I read somewhere that you wanted the appeal to be heard in private, but I may be wrong about that.
I didn't know ever expressed a view.
No, not this application. I meant the.
I think I probably assumed that it would be.
Yes. Obviously, if we.
Both sides?
We have before us two applications by the respondent to the appeal. The first is an application to lift a stay of the order made by Mr. Justice Butcher, which requires the appellant to provide security for the claim in the arbitration in a large sum by 28th November 2022, and which has attached to it a penal notice. The stay was imposed last week by Lady Justice Carr. The second is an application for security for the costs of the appeal. Dealing first with the stay, the present position is that the order made by Mr. Justice Butcher in the commercial court requires the appellant, S3D, to provide security for Oovee's claim in the arbitration by 4 p.m. on 28th November 2022. That is to say, by Monday afternoon, it now being Friday afternoon. The order contains a penal notice so that, in the event of non-compliance, both S3D and its directors and officers may be held to be in contempt of court, with all the sanctions which follow from that. There is a contentious issue whether S3D is able to provide the security. It says that it is not, but Oovee disputes this. The position is that in the course of the arbitration, the arbitrator expressed a conclusion that S3D had been dissipating assets and has taken the view that it would be in a position to provide the security which he ordered. When the matter came before Mr. Justice Butcher on the Section 42 application, he referred to that issue, but said that the court would not review the arbitrator's decision that a peremptory order for security was appropriate, notwithstanding S3D's protestations of impecuniosity. We cannot decide whether S3D would be in a position to provide the security. We must proceed on the basis that in the event of non-compliance with the order made by Mr. Justice Butcher, there is at least a risk that S3D would be found to be in contempt. That indeed is Oovee's position. It says that the attachment of a penal notice to the order obtained from the commercial court was the whole purpose of making its application under section 42. Its position is that if there is non-compliance with the order, then S3D will be in contempt and liable to appropriate sanctions. Mr. Akins for Oovee submits that we must now proceed on the basis that S3D is able to comply and will avoid any prejudice by compliance with the order, because that was the arbitrator's view and because of the way the judge dealt with it. It seems to me that that is somewhat artificial. If there are proceedings for contempt as a result of non-compliance, there may well be a question whether S3D is now in a position to comply with the order. What conclusion would be reached about that, or what its relevance would be to any application to commit for contempt, is not something which we can or should attempt to decide now. We should proceed, in my judgment, on the basis that whatever room for scepticism there may be about positions taken by S3D, there is, at least as Oovee submits, a real risk of contempt in the event of non-compliance with the order, and that there is potentially a question as to S3D's ability to pay. The judge gave permission to appeal to this court, recognising therefore that there was at least a real prospect that his decision was wrong. Certainly the case raises an interesting and potentially important point concerning the scope of the court's powers under section 42 of the Arbitration Act 1996. The appeal has been expedited and is due to be heard on 6th December 2022, that is to say in 11 days' time, those 11 days including 2 weekends. That is necessary because an evidential hearing in the arbitration is due to begin on the 12th of December with an estimate of 5 days. When ordering expedition, Lady Justice Carr acceded to an application by S3D for a stay of this part of the judge's order pending the appeal. That is to say, the part of the order requiring the provision of security for the claim. She did so without a hearing, but with liberty to apply. The respondent, Oovee, has now availed itself of that liberty. Accordingly, we have considered the matter afresh. In applying for the stay to be lifted, Oovee relies on the principle that an appeal does not operate as a stay of any order made by the lower court, and that a stay should only be granted on solid grounds. I accept these principles. It is therefore unnecessary to refer to authority in their support. The question is whether such solid grounds exist in the present case. In my judgment, there are such solid grounds here. If the stay is lifted, there is at least a risk that S3D will be in contempt, and its officers and directors will be liable to imprisonment, fines and asset seizures for non-compliance with an order when there is at least a real prospect that the order should not have been made. The appeal is due to be heard within a very short time, after which it will be finally determined, one way or the other, whether the order was rightly made. In those circumstances, it seems to me that the balance of prejudice is clearly in favour of maintaining the stay until the hearing of the appeal. The imposition of the stay means only that the judge's order, with its penal notice, will be suspended, and the sanction of contempt will not arise. It does not affect the fact that the arbitrator has made an order of which S3D is in breach, with whatever consequences may follow from that. Turning to security for costs, S3D accepts that the condition in CPR 25.13 is satisfied, so that the issue is whether, quote, having regard to all the circumstances of the case, it is just to make such an order, close quote. In my judgment, it is just to do so. There is a history of failures on the part of S3D to make payments which it is obliged to make, including, for example, its share of the costs of the arbitration, which it was ordered to make before there was any question of termination of the arbitration agreement by repudiation. But it is clearly in a position to fund not only these proceedings and the arbitration, but also a multiplicity of other proceedings which have been brought in various jurisdictions. It has been found by the arbitrator to have engaged in dissipation of its assets. There is also evidence that, when ordered by a court to give security, S3D has been able to do so. Finally, the costs of the appeal for which security is sought are relatively modest by the standards of commercial cases. Having regard to the legal costs which S3D is already incurring, I have no doubt that it will be able to provide the security if it chooses to do so. There is no question and no suggestion that an order for security would stifle the appeal. Indeed, Mr. Richard Slade, who represented S3D at this hearing, accepted that security could be provided if the court so ordered. In view of the imminence of the appeal, it is appropriate to make an unless order, so that if the security is not provided, the appeal will be dismissed without further order. It is nevertheless necessary to give S3D some time to provide this security, although I recognise that this means that Oovee will have to incur some of the costs of the appeal before it knows for sure whether the security will be provided. However, in view of the short timetable remaining, that is unavoidable. Accordingly, I would dismiss the application to lift the stay. I would order that, unless S3D provides security for Oovee's costs of the appeal in the sum of £20,000 by 4 p.m. London time on Wednesday, 30th of November, the appeal will stand dismissed without further order. The security may be provided either by payment into court or by an undertaking from the appellant's solicitors that they are holding £20,000 to the order of the court.
As I agreed with my Lord's ruling on anonymity and hearing in private, so I agree with his decisions both on the application to lift the stay and for security for costs.
Thank you both very much. Is there anything further?
Not from this side. We'll draw up an order.
Very good. Well, thank you both for an interesting argument.
Thank you.
Close road.